Vivienne Elborne and others and the HMRC.
Good morning.
Good morning. May it please your ladyships, may it please my lord, Launcelot Henderson. I appear on behalf of the...
Thank you so much.
I appear on behalf of the Appellants, His Majesty's Revenue and Customs, along with my learned friend, Mrs Leslie. My learned friend, Mr Bradley, appears on behalf of the Respondents. Before we go any further, may I check what the court has before it? I'm hopeful the court has a skeleton from each side, a core bundle, a supplemental bundle, an authorities bundle, and perhaps a slim supplementary authorities bundle.
Yes.
I'm grateful. A short route map in terms of what's going to happen. The revenue are the appellants, and therefore the revenue submissions will be made first. That will involve the court first hearing from me, and then from Ms Belgrano. I will be doing two things. First, briefly making some introductory remarks, including sketching out some of the factual and legislative context. And then secondly, less briefly, working through the first 7 of the revenue's grounds of appeal. Once I've done that, I'm sure the court will be ready for a different voice, and Ms Belgrano will address the court in relation to grounds 8 to 10. It will then be the turn of learned friend Mr Bradley to make his responsive submissions, and then finally the revenue's reply. We've agreed a timetable, which I hope the court has seen, and we hope will be satisfactory. Of course, if we can move more quickly, then we will do so. Without further ado, some opening words. This case concerns a tax avoidance scheme. It is an instance of what is known as the home loan scheme. The fundamental issue between the parties, expressed at its highest level of generality and in non-technical language, is: does the scheme work? Does it radically reduce the inheritance tax that would otherwise be payable on the estate of the late Miss Leslie Elborne? The First Tier Tribunal's conclusion was no. The Upper Tribunal's conclusion was yes. The matter now comes before this court. Although the fundamental issue can be expressed succinctly, the court will appreciate that it unpacks into a series of principle and or provision-specific issues and sub-issues. The fact that it does reflects two things. First, the multi-element nature of the scheme. Secondly, the substantial number of legislative provisions and principles arising out of the case law which are or may be engaged. Given these multiplicities, the journey we're going to embark on will inevitably involve close, sometimes extremely close, scrutiny of particular elements of the relevant legislation and particular elements of the arrangements. But I would ask that as we move through the undergrowth, the court does not, as it were, forget to look up and see the view. The First Tier Tribunal described the scheme as, quotes, designed to enable Mrs Elborne to continue living in the property while at the same time reducing the value of her estate by an amount equal to the value of the property. Para 2441 of the First Tier's decision. In my submission, that description is accurate, and is accurate as an intended aim of the scheme. The fact that Mrs Elborne entered into the scheme at all reflected, as her son put it in his witness statement, his mother having, quotes, investigated the options available to try to reduce inheritance tax payable on her estate, and instructing Stephen Wolfe, her solicitor, to set up what I now know to be referred to as the home loan scheme. Witness statement, para 3. It's more than 40 years since Lord Wilberforce said the various things he said in Ramsey regarding analysing fact patterns realistically, so looking at transactions not, quotes, in blinkers isolated from any context to which they properly belong, page 323G, Ramsey, and construing tax legislation purposively. And since then, the courts have consistently endorsed and reminded us of the validity and efficacy, profound efficacy, of those observations and that sort of approach. In this case, the Elborne parties criticise my client's arguments for variously focusing on the wrong bit of the fact pattern, or failing properly to discern Parliament's intention from the statutory language through being too broad brush or otherwise falling into error. I say such criticisms themselves miss the mark. In the context of a case engaging a different part of the taxing code, the Supreme Court contrasted what it referred to as on the one hand, a, quote, normal case, and on the other hand, the, quotes, unusual circumstances of the tax scheme which the court was being asked to consider. That was a case concerning business rates called Rossendale, and in that case, careful attention to the unusual circumstances of the case resulted in the Supreme Court reaching a different conclusion on the interpretation of the legislation than had been reached lower down the appellate ladder. To be clear, in contrasting on the one hand something normal and on the other hand something unusual, the Supreme Court was not attempting to tee up or posit as an end in itself some hard-edged dichotomy to be discerned and then adjudicated upon in every case. Rather, the point was and is that paying close attention to the facts of a particular case really does mean an extremely careful, clear-headed analysis and reflection on what the factual circumstances are and how those circumstances really do or do not mesh with Parliament's intent as expressed in the statutory language. One is reminded perhaps of Lord Walker's remark in the final sentence of his judgment in a case called Tower M Cashback, where he referred to any perceived uncertainty arising from different court decisions in respect of various tax-structured transactions as arising not from the inconsistency of judicial approach and analysis, but from what he called the, quotes, unremitting ingenuity of tax consultants determined to test the limits of the legislation. Tower, paragraph 80.
Well, that's all very well and good. It either works or it doesn't.
Indeed.
So, isn't it better to actually start going through the minutiae and telling us why it doesn't work? I mean, this is a case where the revenue only won on one point in the first tier tribunal. They lost on that point in the upper tribunal. They haven't got permission to appeal on most of the grounds that you want to run. And I, for one, would be very helped as and when we come to those grounds as to why it is said that those grounds satisfy the second appeals test, so that we should give permission. But apart from that, I'm quite keen that we should get down to the nitty-gritty.
I'm grateful, milady.
I think permission was granted by Lord Justice Lewison.
On everything.
Yeah, on everything.
Oh, was he?
Yes, sorry. It's in the... yeah. That's one of the things that was missing from the first effort of the core bundle, which we were supplied with.
Yeah.
Well, my apologies that it was missing, but Lord Justice Lewison did grant permission on everything.
Nevertheless, we appreciate your introduction, but as my lady Justice Andrews says, the real question is, does it work or doesn't it?
Indeed. That's perfect timing, because that is all I wanted to say by way of introductory wording. I'm now going to start by running through the scheme documentation, just briefly. But I'll flag at the outset that at the centre of the arrangements, and tallying with what I said regarding normal and not normal situations, at the centre of the arrangements is an agreement for sale of a freehold interest in a valuable and historic residential property, the Old Rectory, Seaton, Oakham, Rutland, in relation to which there was no electronic movement of money between buyer and seller, there was no physical transfer of cash from buyer to seller, there was no change in the physical day-to-day use and occupation of the property, subject to the agreement for sale, i.e. a snapshot of life at the Old Rectory before and after the date of the agreement for sale would have been identical. There was no completion of the agreement for sale. Mrs Elborne remained the legal owner of the freehold at the time of her death. And while the debt obligation...
Does that matter? And the FTT dealt with that. I mean, you're back to generalities. Let's look. There was a sale agreement. We know what the consideration for that sale was. We know that the note is then assigned on to trustees of the second trust. Let's get to it. We know that Mrs Elborne continued to live in the property that she considered to be her home.
I'm grateful. I was intending to just note the 10 items of documentation that make up the scheme, but I won't do that if the court does not want me to do that.
No, do list them, that's fine.
Just pausing at one point, the fact that the contract was not completed, I mean, does that matter? It used to be a commonplace for contracts for the sale of real property to be left standing in contract, usually for stamp duty reasons. I mean, it doesn't stop the beneficial interest going over, does it? As long as it's a specifically performable contract.
Indeed, my lord. The point I was endeavouring to make was that these are, I say, unusual circumstances, given the nature of the arrangement, and given the fact that it gives rise to a debt obligation which is never discharged, still hasn't been discharged.
But it was a real debt. There's no longer any dispute. There's no argument of sham or anything of that kind.
Correct.
Although that was run and duly rejected by the FTT.
Correct. There was a real debt, but the point I'm trying to make is that the factual circumstances are not irrelevant when one comes to consider the statutory provisions in question. And the reason I've mentioned Rossendale is precisely because you can have a situation where the factual context means that one looks at the legislation with a very clear, keen eye. And sometimes it means that it is cast in a light which might not necessarily be the light in which it has been cast in past cases.
But in a sense, that's music to my ears as far as Rossendale is concerned. But the fact is, I was overruled in that case by the Supreme Court. And anyway, I'll be interested to hear what you have to say about Rossendale, bearing in mind always that it has ultimately to be founded on a construction of a particular provision. And we need to know in due course precisely what it is you're using Rossendale to construe.
Indeed, my lord. The 10 items which make up the documentation of the scheme. Number 1, agreement for sale, which I've already referred to. It's dated the 27th of November 2003. It's between Mrs Elborne and the trustees of what was called the Elborne Life Settlement. Supplemental bundle, page 37. Number 2, trust deed for the Elborne Life Settlement, again dated the 27th of November 2003. Supplemental bundle, page 12. The trustees of whom were Mrs Elborne and her solicitor, Mr Wolfe, and the life tenant for which was Mrs Elborne. Item number 3, a trustee resolution by the life trustees, also dated 27th November 2003, resolving that Mrs Elborne would be given the right to reside rent-free in the property during her lifetime. Supplemental bundle, page 24. Item 4, a letter of wishes in respect of the Elborne Life Settlement, again dated 27th November 2003, from Mrs Elborne to the trustees of the Life Settlement, i.e. herself and her solicitor. Supplemental bundle, page 36. Item 5, the promissory note, also sometimes referred to as the loan note, which had been referred to in the agreement for sale, again dated 27th November 2003, issued by the trustees of the Life Settlement to Mrs Elborne, and stated to have a nominal value of 1.8 million.
And that's at page?
Sorry?
Page in the supplementary bundle?
Page 39.
Thank you.
The number 1.8 million being the purchase price under the agreement for sale. Item number 6, a further trust deed called the Elborne Family Settlement, dated 8th of December 2003, supplemental bundle, page 47, naming Mrs Elborne's 3 adult children as trustees and principal beneficiaries, Mrs Elborne not a beneficiary. Item number 7, letter of wishes in respect of the Elborne Family Settlement, dated 8th of December 2003, from Mrs Elborne to the trustees of the Family Settlement, supplemental bundle, page 60. Item 8, a deed of assignment of promissory note, dated 8th of December 2003, supplemental bundle, page 61, assigning the note from Mrs Elborne to the trustees of the Family Settlement. Item 9, a notice of assignment of debt from the family trustees to the life trustees, dated 8th of December 2003 in respect of the promissory note. Supplemental bundle, page 65. And finally...
I'm sorry, I missed that. 65.
Supplemental bundle, page 65.
65, thank you. Sorry, and lastly...
And finally, item 10, a trustee resolution by the trustees of the Family Settlement, dated the 8th of December 2003, supplemental bundle, page 67, which, among other things, acknowledged receipt of the assignment of the promissory note. There were numerous peculiarities and or shortcomings in respect of the implementation of the scheme. They're detailed in the FTT's decision at paragraphs 22 to 27. They included, for example, various documents not becoming effective until subsequent to the date that they bore, by virtue of not being signed by all signatories at the time. FTT, paragraph 27. Trustees of the family settlement resolving to register a restriction over the property at the land registry.
It was unregistered land.
Correct, it was unregistered land, so they couldn't have done it. And in any event, they didn't take the step they could have done, which perhaps was to register a caution. FDD, paragraph 1512.
Why does any of this matter? We're a bit hopeless.
The shortcomings are listed in the FTT's decision. I will not list them out, I'll move on.
Well, by all means, mention them if they're actually relevant, but as my lady says, the real question for us is whether or not the combination of all these various documents resulted in a scheme which works or doesn't.
The reason I say they're relevant is because the context matters. The context really does matter. The factual background.
Tell me then, so that I can cross that bridge, why, if I can put it that way, the hopelessness, the what might be said were mistakes, etc., which we find in the FTT decision at 22 to 27, is a background which feeds in to your construction.
Well, again, I would refer to Rossendale, which was a case where, on the face of things, the legislation was very clear in terms of who the owner was. It was the party with an interest in possession. But in what Lord Briggs called the unusual circumstances of the tax scheme in front of them, the Supreme Court took the view that Parliament could not have intended that the owner meant the party with a right to possession in, as it were, a traditional orthodox real property fashion. The Lord said that the desire for legal certainty did not go as far as it were, applying an orthodox construction in the face of what was plainly not meant to be captured by Parliament's intent. Now, your ladyship will say that all sounds a bit broad brush, I suspect, but I'm trying to tee up the point that the factual matrix is not irrelevant when one comes to look at what went on. The fact that something isn't a sham does not mean that one, as it were, airbrushes some of the peculiarities when one comes to look at a particular provision and say, what does Parliament mean by these words in relation to these facts?
Yes, and I was asking, how do the inefficiencies in putting the scheme into practice help us?
Well, I hope to bring that out as we go through the
Okay,
the
let's
particular
just do
provisions.
it.
There were a number of further inefficiencies. I'm not going to simply list them out, but they are
But they're at the FTT 22 to 27, you said?
correct.
Yeah.
The FTT did note that these various features did nothing, quotes, to assist the appellant's case, but ultimately found that, despite such matters, the parties had intended to implement the scheme. FTT, paragraph 26(1). Of course, one thing that absolutely did happen is that following Mrs Elborne's death, the executors of her estate submitted an inheritance tax account on the footing that the scheme was effective, asserting that the arrangements had reduced Mrs Elborne's estate by £1.8 million. Yeah. Supplemental done under
Well, if they hadn't, we wouldn't be here.
On one aspect of the scheme, I got this right, was that it involved the making of a potentially exempt transfer by her on the assignment of the benefit of the note to the trustees of the family settlement, and that it would indeed have given rise to a tax charge had she not survived the gift by 7 years, which she did by a fairly narrow margin.
That is correct, my lord.
So to that extent, there's built into the scheme a perfectly normal standard bit of inheritance tax law, which could, on slightly different facts, have landed the family with quite a big tax bill. I mean, that may or may not be relevant, but one needs to perhaps, if we're looking at the scheme as a round, we have to include in what we scrutinise that aspect of it which could have gone the wrong way so far as tax saving is concerned.
Indeed, my lord. That is all I want to say about the facts, at least for now. A word on statutory setting. We're obviously going to spend a good amount of time looking at certain provisions in detail. I would just refer to a small number of sections flagging some basic points. The Court will want to keep in mind Section 4 of the 1984 Act. That's at Authorities Bundle 725. I don't think we need to turn it up now. But it says that on the death of any person, tax shall be charged as if immediately before his death he'd made a transfer of value and the value transferred by it had been equal to the value of his estate immediately upon his death. So that brings the concept of estate into play. For that, we go to Section 5. Section 5.1 tells us that, quotes, a person's estate is the aggregate of all the property to which he's beneficially entitled. Section 272 says that property includes rights and interests of any description. Section 5 also tells us that the value of a person's estate is or can be reduced by liabilities. So Section 5.3, in determining the value of a person's estate at any time, his liabilities at that time shall be taken into account, except as otherwise provided by the Act. And also relevant for our case is Section 49, which is a deeming provision. Section 5.1, as I noted a moment ago, states that a person's estate is the aggregate of all the property to which he's beneficially entitled. Section 49.1 uses the same words, beneficially entitled, providing that a person beneficially entitled to an interest in possession in settled property shall be treated for the purposes of this Act as beneficially entitled to the property in which the interest subsists. So taking stock, what Section 49 is doing, I think on any view, is, as it were, further sculpting what falls within a person's estate, providing that if a person is beneficially entitled to an interest in possession, in settled property, then they're treated as beneficially entitled to the property in which the interest in possession subsists.
Yeah, and that is so regardless of the length or duration of the interest in possession. I mean, you could have a short-term interest in possession for a matter of weeks or months or something, but that would still, the deeming would still work with its full literal force, would it not?
Yes.
While the interest still subsists.
Indeed.
And this is a very striking feature of the settled property regime under originally CTT and now IHT, that it does include this very fundamental manipulation of the real world.
Indeed. And Section 49 follows, as I've said, Section 5 having defined an individual's estate by reference to beneficial entitlement to property, and Section 4 stating that inheritance tax is charged on the value of a person's estate. Now, all those provisions are within the 1984 Act, but it's also worth mentioning at the outset the connection with the 1986 Act, the Finance Act. Section 114 of the Finance Act states that Part 5 of the Finance Act is to be, quotes, construed as one close quotes, with the Inheritance Tax Act 1984, and save in relation to one section not relevant to our case. Construed as one, for the court's note, that's page 55 in the authorities bundle. And section 5 of the Finance Act is headed Inheritance Tax, and it includes, amongst others, section 102, which is headed Gifts with Reservation, and section 102A, which is headed Gifts with Reservation, Interest in Land, and section 103, which is headed Treatment of Certain Debts and Encumbrances. We'll obviously be looking at these provisions and others in more detail, but hopefully that gives just a little indication of some of the basic legislative architecture.
And in very broad terms, it was that raft of amendments which turned what was originally sort of CTT into a hybrid between CTT and estate duty by importing into the scheme a whole lot of provisions which most people thought were long dead and buried, but come back to haunt us ever since.
That's right, my lord. I mean, certainly what we have today is an evolution of, well, it's post-1986 inheritance tax, it's it's capital transfer tax, it's estate duty, before that it's account duty. So there's this long legislative legacy going back, I think at least to about 1890 or so. But you're right.
Certainly doesn't make life any easier.
No, it doesn't. The court will be pleased to hear that that's all I wanted to say by way of scene setting. So I'm now going to turn to our first grounds of appeal. So, if the court has our skeleton argument, I'd be grateful if we could turn to page 2. And on page 2, hopefully there's a table setting out our grounds of appeal. It will be seen that the first 3 all concern section 103. And beneath the table, one will see paragraph 6, which begins with the underlined words, introduction in respect of grounds 1 to 3. I'm going to start by addressing the court in relation to these 3 grounds. At paragraph 6, we say the revenue submit the UT erred in law in concluding that in valuing Mrs Elborne's estate, the liability arising under the note was not subject to abatement pursuant to section 103. Such error involved the UT misconstruing section 49 and section 103 in the following ways. And then we go on to make various points. So to recall the context, the FTT had determined the appeal in the revenue's favour on the basis of its analysis of section 49 coupled with section 103. The FTT's analysis, in short, had been that the deeming, well, number one, the deeming in section 49 was to be followed through to the anti-avoidance provision of section 103. And the FTT adopted that position on the basis of a number of building blocks. Number one, the applicable principles in respect of deeming as articulated by the Supreme Court in Fowler, paragraph 27, Authorities Bundle 476, including that the court should not shrink from applying the fiction created by the deeming provision to the consequences which would inevitably flow from the fiction being real. FTT 230. Fowler 27.5. Point 2, the fact that the relevant part of the Finance Act 86 was to be construed as one with the Inheritance Tax Act 1984. That point is implicit rather than explicit on the face of the FTT's decision, but it's a necessary building block. Or at least it's a logical link in the chain. And then number 3, the terms of section 103, which when applied to the facts of the case, the FTT found meant that the liability arising under the loan note did not reduce the value of Mrs Elborne's inheritance tax estate as the scheme had intended, but rather was subject to abatement corresponding to the value of the freehold of the old rectory, which was consideration given in return for the loan note. So for the pith of the FTT's decision, could we go to the FTT's decision, please? Page paragraph 230, that will be core bundle, page 277. Picking it up at the second sentence, since there is a necessary implication in the language of section 49 to the effect that the debts of the settlement should be treated as having been incurred by the person owning the interest in possession, it is then necessary to apply the principles set out by Lord Briggs in Fowler once again, this time in determining whether the deeming should be carried across when construing section 103. It seems to us that on the basis of the relevant principles, that is the case. Doing so is entirely in accordance with Lord Briggs' principles, and in particular his fifth principle, in that it's a consequence which flows inevitably from assuming the fiction implicit in section 49 to be real. And his fourth, in that extending that consequence to section 103 does not produce an unjust, absurd, or anomalous result. On the contrary, extending the fiction which is implicit in section 49 in that way means that section 103 is fulfilling its manifest purpose. To adopt any other approach to the language in the section would drive a coach and horses through that purpose.
I'm very sorry, Mr. D. I'm possibly looking at a differently paginated version of the FTT, which is the maybe because I extracted it from the bundle in one of the bundles in one of the earlier incarnations. Which are the paragraphs?
Paragraph 230 of the FTT's decision.
Thank you. Yeah. Yeah, got it. Thank you.
So that's what the FTT had held, and was one sees expressed in fairly robust terms. A contrary analysis would drive a coach and horses through section 103. And in making that finding, they were agreeing with another tribunal decision, a first-tier tribunal called Pride, paragraph 146. We don't need to turn that up at the moment. We'll come back to that in due course. Now, the Upper Tribunal took a different view. That's to say, the Upper Tribunal concluded that in analysing Mrs Elborne's estate, the liability rising under the loan note did reduce the value of Mrs Elborne's estate. I say the Upper Tribunal was wrong to do so. That's the focus of our grounds 1 to 3. And as we note in our skeleton at paragraph 7, grounds 1 to 3 to an extent interrelate and overlap. There are a number of pieces in the jigsaw put together in advancing the various points in play here. Essentially, there are three. There's section 49 itself, there's section 103, and there's the case of St Barb Green. We've looked at section 49 albeit briefly. That's the deeming provision. So I'm now going to focus for now on section 103, which we haven't looked at yet, before then bringing in section 49 and St Barb Green into the analysis. So, section 103. I think it'd be useful if we had that to hand, so I'd be grateful if the court would go to Authorities Bundle, tab 8, page 53. So, the first tribunal had described section 103 as dealing with a, quote, type of avoidance involving the creation of a liability. That was FTT 243. And that's consistent with how the literature tends to refer to section 103. In terms of the mechanics of how it works, at a high level, one can see section 103 as comprising 4 elements. That's how the Upper Tribunal expressed the structure of section 103 in summary form. Upper Tribunal decision, paragraph 15. Just to run through those 4 elements or components. Number 1, the premise of section 103, as it were, is that you're in a situation where you are, quote, determining the value of a person's estate immediately before his death. That's the first line of section 103, sub 1. Element 2, if you're in that situation, then under section 3 you're looking for a, quote, liability consisting of a debt incurred by him, i.e. the deceased, which ordinarily would be taken into account in determining the value of the estate. In other words, the situation needs to be such that account would be taken, apart from this subsection, of the liability in question. Yes, sorry, or an encumbrance created by a disposition made by him. So there are two possibilities, debt incurred by or encumbrance created by. And it's the first of those, debt incurred by, that we're focusing on. First instance, the revenue also ran an encumbrance argument. The FTT found against the revenue on that, FTT 218, and the revenue did not seek to appeal that to the Upper Tribunal. That's the second element. Third element, regarding consideration. The position needs to be such that, quotes, any of the consideration given for the debt or encumbrance consisted of A, property derived from the deceased, or B, consideration not being property derived from the deceased given by any person who was at any time entitled to, or amongst whose resources there was at any time included any property derived from the deceased. So again, there are two possibilities, and in the present case, it's the first of those which we're focused on. 103(1)(a), property derived from the deceased. And then finally, the fourth element, as it were, if you have those building blocks in place, then the liability, quotes, shall be subject to an abatement to an extent proportionate to the value of, and then that consideration, i.e. any of the consideration given for the debt, which consisted of property derived from the deceased. The Upper Tribunal noted, in relation to those four components, that there was no dispute in relation to 1 or 4, Upper Tribunal paragraph 16, i.e. in relation to 1, not in dispute that the first component is met, i.e. this is a situation where we're determining the value of a person's estate immediately before death. And in relation to element 4, not in dispute that the fourth element is met, i.e. if section 103 otherwise applies, then the consequence of section 103 applying would be to reduce the value of the liability, the note, to nil, as the totality of the consideration was the property. Upper Tribunal decision paragraph 16. Quotes, it was agreed that the consequence of section 103 applying would be to reduce value of the liability to nil. So no problems with 1 and 4. Therefore, what we're focusing on is 2 and 3. 2 has been labelled the debt incurred issue, which in turn brings into focus section 49 and the case of St Barb Green. That's the terrain covered by grounds 1 and 2. 3 has been labelled the property derived from issue. That's ground 3. So, debt incurred by. And here I'm at paragraph 8 and following of my skeleton argument. So taking the analysis in stages, the position is as follows. The court will recall we've got section 49, which provides that a person beneficially entitled to an interest in possession in settled property shall be treated for the purpose of the Act as beneficially entitled to the property in which the interest subsists. And the FTT had construed that as entailing, quotes, that the debts of the settlement should be treated as having been incurred by the person with the interest in possession, FTT 228. And accordingly, carrying that across to section 103, it meant that a liability consisting in a debt incurred by him covered the situation of an interest in possession beneficiary who, by virtue of section 49, was treated as bearing the liabilities of the trust. That was the FTT's analysis.
So it depends on the proper construction of section 49, purposely construed.
It does. Now, the UT disagreed with that analysis And we've summarised the nature of the UT's disagreement in paragraph 9 of our skeleton argument. I wonder if the court would be kind enough just to read or remind itself of what we say at paragraph 9. Thank you. So the court will see that there are references to 3 passages from the Upper Tribunal's decision there, paras 51, 58.3 and 58.7. I'd like to go to those, please. The Upper Tribunal's decision, paragraph 51, can be found at core bundle, on my numbering 137, but in any event, paragraph 51. And the reason I'm taking it carefully is because it's quite careful stuff and one has to see why particular positions are taken on particular points. So at 51, we can see the Upper Tribunal saying we start from the position that section 49.1 does not make any express provision in relation to the liabilities of the settlement. Mr. Justice Mann had treated as making provision for the deduction of settlement liabilities when calculating value of property to which the deceased is to be treated as being beneficially entitled. However, neither the language of section 49.1 nor the decision in Sutton Barb Green makes any reference to the parties to those liabilities, including whether the holder of the interest in possession is treated as owning or having incurred the trust liabilities. Then at paragraph 52, the Upper Tribunal rejects a particular submission being advanced by my learned friend, and then at 53 goes on to consider some of the case law, including Fowler. And then at 58, the Upper Tribunal makes a number of points which purport to apply the principles, principally from St Barb Green and from Fowler. The 2 passages we cite in our skeleton at paragraph 9 are 58.3 and 58.7. At 58.3, having applied the deeming in section 49.1 for the purpose of bringing the settled property into the estate of the holder of the interest in possession, there is no obvious need for section 49.1 to be given a construction which goes beyond this. Parliament could have said expressly that liabilities incurred by the trustee were to be treated as liabilities of the holder of the interest in possession, but it did not do so. It was in any event not necessary for them to have done so to ensure the settled property was brought within the holder's estate. And then 2nd to 4th sentences of 58.7, if I may, we're not persuaded that the deeming in section 49.1 requires that the holder of the interest in possession be treated as personally liable for the debts of the settlement. Viewing section 49.1 in its statutory context, it's not necessary to impose such a construction on the language of the provision. The provision makes sense and fulfills its statutory purpose, as interpreted by Mr. Justice Mann in St Barb Green, in that it operates to bring the settled property into the estate of the holder of the interest in possession. The notion of property from which liabilities have been notionally deducted at 12 does not require that settlement liabilities are treated as being liabilities of anyone other than here, the like trustees. So, why do I say that the Upper Tribunal went wrong in saying what it says there and landing where it lands? In a sense, the points overlap here, but nevertheless, fundamentally it's 3 points. Number 1, inconsistency. Number 2, getting into difficulty with the case of St Barb Green. And number 3, a failure to construe section 103 properly. I'm going to work through those now.
Section 103, not section 49.
Well, it's a combination, but including section 103.
Well, okay. I mean, don't you have to say that section 49 bears the meaning that they've rejected?
Well, I do say it bears the meaning that the Upper Tribunal have rejected, that's right. So, here I'm basically at paragraph 10 and following of our skeleton, So I say the Upper Tribunal was adopting a logically inconsistent approach in its construction of Section 49.1 because the Upper Tribunal itself acknowledged that Section 49.1 does not make any express provision in relation to trust liabilities at all. So, by on the one hand, reading into Section 49.1 a purported requirement to deduct the value of liabilities in arriving at the value of trust property deemed to be in Mrs Elborne's estate, despite Section 49.1 not referring to liabilities. Yet at the same time, on the other hand, holding that the effect of the deeming is so limited as not to be taken into account at all when considering a related provision, Section 103, which does expressly deal with liabilities, seemingly because Section 49 makes no express provision in respect of liabilities, we do say that there's an inconsistency there. We're told that the two acts are to be construed as one, Section 114, the Finance Act 1986. Therefore, we do say the Upper Tribunal went wrong to part company with the first-tier tribunal, who, as we say, construed Section 49 as being to the effect that the debts of the settlement should be treated as having been incurred by the person owning the interest in possession, FTT 228, and then treating that deeming as still being in play, as carrying across when one looks at Section 103.
Well, can we just look at Section 49, please?
Yeah.
To make that good. Page 28. A person beneficially entitled to an interest in possession in settled property shall be treated for the purposes of this Act as beneficially entitled to the property. Okay. That to me suggests that they are treated as the owner of the property. Doesn't suggest to me that they're treated as a trustee. Am I wrong?
Well, it certainly says that they're to be treated as beneficially entitled to the property, so owner of the trust property. Mm-hmm. The question then is, what does one do about trust liabilities?
Yes. Yes, that is the question.
Yes. But on the face of it, a person with a beneficial entitlement in property is not usually the trustee of that property, it's the person with the equitable interest in it. So just on the face of it, it's saying, because you've got an interest in possession which wouldn't normally treat you as having an interest in the property, we're going to deem that in fact you are being treated as if there was a settlement and you were the beneficial, you had the beneficial or equitable estate in the property. Thus far, thus good. Understand all of that. Now, where do we go from there to put them in a position which, as I understand your argument, puts them in the position of being a trustee of the property?
Well, it puts them in the position of a party that, for the purposes of Section 103, is treated as having incurred the liability. We're going to come on to St Barb Green in a moment.
No, before we do, I mean, I just want to follow the argument. Are you saying that they are to be treated as if they were trustees of the property? Or is it some other route that you're taking so that I can actually follow the logic? Because you say there's an inherent inconsistency in the way in which the tribunal has approached it, and I'm just trying to get my head around what the inconsistency is at the moment.
I'm grateful, my lady. The inconsistency is that Section 49.1 does not refer to liabilities at all.
No.
The Upper Tribunal position is that the value of liabilities is to be taken into account under Section 49.1. And that's despite it not referring to liabilities at all.
Well,
And yet,
pausing there, just before we get there, of course Section 49 doesn't deal with liabilities, but it puts somebody in the position as if they were, they had a beneficial interest in the property. So when you start looking at liabilities, you then ask yourself, if that person were the owner or somebody who had an equitable interest in the property, what liabilities would they then incur which could be deducted or set off against the tax? And that's a different provision. It's not Section 49 at all, is it?
well, the argument that I'm making is this. Section 49(1) does not refer to liabilities.
Yes.
No.
However, the Upper Tribunal said that nevertheless, you do need to understand it as factoring in liabilities in a way. Doesn't say liabilities, but
And that's the St Barb Green route.
it is.
Oh.
So it doesn't say liabilities at all, but you've got to read it as saying something about liabilities anyway. We're going to come on to St Barb Green, but that's what it. But the Upper Tribunal is saying 49(1) doesn't mention liabilities, but you've got to understand that in a way it does. It is in a way dealing with liabilities.
Why can't one get the answer in relation to liabilities by looking at the provisions in the Act which do expressly deal with them? Like Section 5, subsection 3, and this is 162. I mean, I've got the number of it wrong.
Well, that's precisely the argument I am and will be making, my lord.
Well, okay, but again, that doesn't. So in that case, that's nothing to do with Section 49 deeming at all, is it? It's just. I mean, everyone agrees it's a matter of common sense. You've got to make some kind of allowance for liabilities which are an encumbrance on the relevant property, because otherwise you end up with taxing far too large an amount. But
I have three submissions. The first is that I say the Upper Tribunal is being inconsistent. The way in which I'm saying that is that they're saying, on the one hand, you've got to read 49(1) as dealing with liabilities in some sense, despite the fact it doesn't say liabilities. But on the other hand, they're saying that because it doesn't mention liabilities, you don't pay regard to it when you come to look at Section 103. So they're saying one thing despite the fact it doesn't mention liabilities, and another thing because it doesn't mention liabilities. And I say that is a logical inconsistency. But it's also true to say that the reason they're saying what they're saying, or a reason they're saying what they're saying regarding it factoring in liabilities in a sense, is because of what is said in St Barb Green. And so that's the first point. I say there's a logical inconsistency. They say one thing on liabilities despite the fact it doesn't mention them, and another thing on liabilities because it doesn't mention them. And then beyond that, I say one has to look at St Barb Green to sort of take the story a little bit further.
The inconsistency being between 3 and 7.
Forgive me, I've put down the Upper Tribunal's decision.
Sorry, I was just looking at the paragraphs, just so I really understand the point.
Yeah.
3 says there's nothing in Section 49(1) which expressly deals with the point. It's all to do with settled property being brought within the holder's estate, and it has nothing to do with liabilities. And 7 just trying to understand what the logical inconsistency is here.
The logical inconsistency is that, as I've said, they seem to be making one point despite the fact there's no reference to liabilities, and another point because there's no reference to liabilities.
But in each case, they're saying there's no reference to liabilities. So they're not saying in one case, well, there is a reference to liabilities, or it's to be deemed as having a reference to liabilities, and in the other case, that there is no reference to liabilities. That's an inconsistency. But I don't follow why there's an inconsistency if both premises are on the basis that there is no reference to liability.
I'm not saying there's an inconsistency in the sense of, as it were, a mathematical inconsistency. The point I'm making is that we're dealing with a provision which does not mention liabilities at all.
And the
And yet-
tribunal says so.
Indeed. So they say it doesn't mention liabilities at all, but take the position that nevertheless you have to read it as dealing with liabilities in a sense.
Which paragraph says that? 7. Because I must admit that's not how I read it. And I'm struggling to understand how you do.
So perhaps if we go back to paragraph 51 of the decision, we start from the position that section 49.1 does not make any express provision in relation to the liabilities of the settlement.
Right.
They then go on to note that it's been treated by Mr Justice Mann as making provision for the deduction of settlement liabilities. So the first point is this: they recognise it doesn't refer to liabilities at all, but nevertheless they are.
A judge has said that it does.
Yeah.
By some reference. Which
Yeah.
in due course you're going to say is either right or wrong. Yes.
Yes. So here they're recognising that there's no reference to liabilities, but despite that they're saying nevertheless it's to be treated as making provision for the deduction of liabilities. But then they pray in aid, as it were, the fact that there is no reference to liabilities by saying when you come to section 103, you no longer need to bear in mind section 49 at all. So at 58.3, Parliament could have said expressly that liabilities incurred by the trustee were to be treated as liabilities of the holder of the interest in possession, but it did not do so. Second sentence of paragraph 58.3. So the point I'm trying to make is that we're dealing with a situation where everyone agrees it doesn't mention liabilities, but nevertheless, despite that, the Upper Tribunal is saying, with Mr Justice Mann, you've got to read it as dealing with liabilities, at least in some sense. But, nevertheless, the Upper Tribunal is then praying in aid the fact that it doesn't refer to liabilities in saying, when you go on to look at an adjacent provision, one that is to be construed as one with the 84 Act, the fact that the Parliament didn't expressly say anything on liabilities is a relevant point. That's the point I'm trying to make. So it's the juxtaposition between 51 and 58.3. But I fully recognise that to flesh that point out, as it were, we need to have a look at St Barb Green. Does that answer
Yes, thank you.
Milady's question?
Thank you.
What they're saying at 58.7 is, well, at 58.3, it doesn't say anything expressly about liabilities.
Yep.
58.7, they accept Mr Justice Mann in part, and then they say, nevertheless, that doesn't help, because whose liabilities are there? Are they? And Section 49 doesn't require it to be the liabilities of the life tenant. That's what they're saying at 58.7.
That's right, Milady.
So it doesn't matter.
That is what they're saying.
Okay, so we go to St Barb.
Yes. So, St Barb Green, this is Authorities Bundle, page 564.
Could you give me the tab?
Certainly.
Thank you. 33, apparently.
Yeah, quite so.
Thank you very much.
So, St Barb Green is referred to in the passages that we've just looked at. It's referred to in 58, in Upper Tribunal 51. It's also referred to in Upper Tribunal 58.3. And in terms of the submissions I'm making, I'm here at paragraph 11 and following of my skeleton argument. And I'm going to make two submissions. I'm going to make a primary submission. This is skeleton paragraphs 12 to 13, which is that the court's preferred analysis in St Barb Green, essentially St Barb Green paragraph 12, should be departed from. And I'm going to make a secondary submission. That's our skeleton at 14 to 20, which is that even if the court's primary analysis in St Barb Green is not to be departed from, in the present case, the Upper Tribunal nevertheless misconstrued section 49.1 and misunderstood and or misapplied that primary approach in St Barb Green. Before then, a very brief summary or reminder of what St Barb Green was about. It was a case concerning the 12th Duke of Manchester, Angus Charles Drogo Montague. He died in July 2002. At the time of his death, he had personal assets of approximately 5,000 and more substantial liabilities. There was a net deficiency in his estate of approximately 45,000. See that at St Barb Green, paragraph 2. He also had an interest as life tenant under 3 settlements, which held certain assets. One contained jewellery on loan at the V&A, one comprised securities, one comprised certain sums which had been used to acquire the Duke's house. By virtue of section 49, the assets in which he was interested under the 3 settlements were treated as part of his estate. The question before the court was whether the excess of his liabilities over his assets in what was referred to as his free estate, his personal non-trust estate, could be used to reduce the value of the assets comprised in the 3 settlements for the purpose of computing the amount chargeable to tax on his death. The court held that it couldn't. The deficit in the Duke's personal estate could not be used to reduce the surplus. So
You're saying it was wrong about that and it should?
No, I'm not, my lady. I'm just setting up what this case was about. So that's what the case was principally about, and that's what the court held.
And so that suggests that the 2 capacities are hermetically sealed in the sense of liabilities which you incur personally only go against your personal estate, and liabilities which relate to the interest in which you have a life interest and trust. The trust applies. You're looking separately. You can't go from one to the other.
It's true that that's how I think inheritance tax and estate duty has been managed over the years, and that is what it held, and it did so in line with a case called Re Barnes, which is a 1930s case. Its particular relevance for our purpose is what the judge says about section 49. Could we go to paragraph 12 of the decision, please? And the key passage runs from the second sentence, which begins just above letter C in the left-hand margin, inheritance tax is charged, down to the end of the sentence, ending liabilities have been notionally deducted, just above letter E in the left-hand margin. I'll read it out if I may. Inheritance tax is charged on death by virtue of the deemed transfer of value in section 4. As a transfer of value equal to the value of the deceased estate immediately before his death. His estate is the aggregate of all the property to which he's beneficially entitled. The word property is important here. It's not defined for the purposes of section 2, for these purposes. Section 272 of the 84 Act contains a partial definition in that it states what the expression includes but not what it means. But it is important to note that section 49, which brings in the settled assets, does so by deeming the deceased to be beneficially entitled to the property in which his life interest subsists. And then these are the key words. It does not say net property, i.e. the value of the property, net of trust liabilities, but that is what it must mean. And the parties in this appeal both agree that in practice that's the effect the revenue gives to the section. Thus in section 49.1 we have the notion of property from which liabilities have been notionally deducted.
Beneficial interest is in the net results. And he goes on, and then so he's construing the word property in section 49(1) in a particular way.
He is, and I'd be grateful if the court would perhaps read on to the foot of the paragraph. Thank you. So, just to take stock and to keep the point tied to our present case, what we're considering is whether an interest in possession beneficiary, which Mrs Elborne was under the Life Trust, who was stated in section 49, quotes, is treated as beneficially entitled to the property in which this interest subsists, close quotes, is also to be treated, as the FTT held, FTT 228, as having incurred the liabilities of the trust in which that person has the interest in possession. When
That would be consistent with Mr Justice Mann's approach, because he's treating property as property net of the liability of the trust. If you're being treated in the same, if you've been put in the position of being the owner of the net amount, then the liability's got to be taken into account, surely.
Yes.
It's a consistent reading with St Barb Green.
Correct. The FTT considered they were doing what they were doing consistently with St Barb Green. So we say I have two submissions on St Barb Green. I do say the primary analysis in paragraph 12 should be departed from, but I also say if I'm wrong about that, then in any event, that doesn't mean that the FTT got it wrong. The
It should be departed from, notwithstanding that Mr Justice Mann says that in practice that's the effect the revenue gives to the section. Revenue now want to say that the way they've been treating it is wrong.
Well, paragraph 13 sets out the primary contention that the revenue was putting in the case. So I'd like to develop the argument, if I may. So the position I've just articulated, as I say, the FTT said that was the right analysis. The Upper Tribunal said it was the wrong analysis. And in support of the Upper Tribunal's position, the Upper Tribunal pointed to the fact that in St Barb Green there's no reference to, quote, whether the holder of the interest in possession is to be treated as owning or having incurred the trust liabilities. Upper Tribunal, paragraph 51. Final sentence, Upper Tribunal, paragraph 51. So the question is that a good point? It is true there is no such reference in St Barb Green. But it obviously only assists the Upper Tribunal to rely on what the court says in St Barb Green at 12, if what the court says in St Barb Green at 12 is sound. My primary submission, as I've already alluded to, is that St Barb Green paragraph 12 is not sound, it's problematic and should be departed from. I'm now going to make that good. And here I'm at paragraph 12 and following of my skeleton argument. So, in working through paragraph 12 of St Barb Green, the court will have noted that in construing section 49(1), Mr Justice Mann says that it, i.e. section 49, does not say net property, i.e. the value of the property net of trust liabilities, just below letter D. Now, just pausing there, that is true. Section 49 does not say net property. And since it doesn't say net property, neither does it define the concept in the way that the court defines it. Self-evidently, it does not define net property as the value of the property net of trust liabilities. But the judgment nevertheless goes on to say, but that is what it must mean. But I say, why? Since it's clear in the very next paragraph, paragraph 13, that that's not the only possible analysis and construction. We'll come to 13 in a moment, but before we do that, it's perhaps worth noting, having stated boldly in paragraph 12 that when section 49 refers to property, it must be using the word in some special sense, i.e. a sense not articulated at any rate expressly under the Act. The reasoning then, I'd suggest, becomes a little bit more tentative in the remainder of paragraph 12. As Mr. Justice Mann works through the apparent or possible consequences of that construction. I won't read it out again because the court has looked at it. But where Mr. Justice Mann gets to is that the combination of section 49 plus section 5.1, it's that combination that does the work of netting off the value of liabilities. Not, somewhat surprisingly, section 5.3. The reason I say somewhat surprisingly is because neither section 49 nor section 5.1 refers to value at all. Whereas in contrast, section 5.3 does refer to value, and as it happens also expressly refers to liabilities. So for the Upper Tribunal in the present case to found its position in relation to section 103 on what the court says in St Bark Green at 12 in relation to section 49 is, in my submission, at least not obviously a solid foundation. And the possible shakiness of the foundation is perhaps also indicated by what the court says in St Bark Green immediately following paragraph 12. At 12 it said that section 49 must have this interpretation. It must mean net property. But then if we look at paragraph 13, the court sets out an alternative analysis. So there would seem to be more than one possible analysis after all. If we see the second sentence of paragraph 13 and following, however, if my reasoning is wrong, then I nevertheless consider the approach of the revenue, which is to consider the words taken into account, as in section 5.3, is correct in the alternative, and this leads to the same conclusion. The argument of the revenue, we remembered, is that one takes liabilities into account by offsetting them against assets out of which they can be properly met. But no further, because that's what section 5.3 provides. Now, it's important to keep in mind that the focus in St Bark Green is a different one from the present. It wasn't looking at section 103. But, nevertheless, what is relevant, I say, is that this alternative analysis, paragraph 13, which focuses on section 5.3 as doing the work, when it comes to deducting the value of certain liabilities, has on the face of things a good deal going for it. As I've already said, section 5.3 expressly refers to value and liabilities. Also, section 5.3 expressly caters to the fact that not all liabilities will be taken into account. Got these words at the end of the section, except as otherwise provided by this Act. And we would say that that's precisely because there are sections such as section 103. Not all liabilities will, as it were, make the grade. And if one's free from the shackles of trying to work with this notion of net property, one is not then faced with possible conundrums which seem to flow from that when one comes to consider section 5.3. For example, if we're working with net value under section 49 and section 5.1, what does value actually mean when one gets to section 5.3? Does value mean net value? Or does it mean something different? I'd suggest it's not entirely straightforward. In St Barb Green 12, Mr Justice Mann says at one point that he accepts that the nature of section 35, section 5.3 could be clearer, or would be clearer without the comma. I don't find the point entirely clear. In any event, is it right? Isn't section 5.3 clear enough? Might the comment perhaps suggest a difficulty with finding a harmonic working together between the non-expressed, non-statutorily defined net value concept, reading of section 49 and 5.1, and section 5.3. At one point in paragraph 12 of St Barb Green, it suggested that section 5.3 is confirmatory. But query, is that an accurate way to describe what section 5.3 is doing? I mean, one might say, how can it be right as a matter of policy or construction to circumvent 5.3, which appears to make the point express that not all liabilities will be factored in?
So the upshot is the upshot that if you've got a beneficial interest in property, which is deemed as a result of 49.1, you can't take account of any of the liabilities in relation to that property, even though if you actually own the property outright, you could.
Well, the lady has, if I may say so, I think touched on quite a key point, i.e., if one goes with the St Barb Green reading of paragraph 12, but doesn't allow the FTT interpretation to go with it, which allows the deeming to go through to section 103, then how do you ever get to ask the fundamentally basic question, is this liability deductible or not?
I'm just standing back and thinking a bit about it from the revenues point of view. I mean, is the bottom line on your interpretation that if somebody has a life interest in a settlement under a property, then effectively they're taxed on death on the full value of that property with no deduction from it. But if they own that property outright, then they'd be able to deduct any liabilities that they personally incurred on the property. That's all I'm asking. Because it seems to me to be the concomitant of your argument because of the way that 5.3 operates.
My lady, if I may, I will come back to that.
Please do. Have a think about it. I didn't mean to bowl you a fast ball.
No,
I'm just
no.
trying to look at the big picture at the moment to see what the ramifications of the argument are, because it seems to me that what Mr Justice Mann was trying to do was to head off at the pass a possible inadvertent consequence of a literal interpretation of the word property by saying, well, it's got to be net because otherwise there's no basis on which you can take the liabilities off, and that wouldn't be right.
I absolutely agree with that, my lady. And the points being raised are helpful points in terms of
Have a
trying
think
to work through
about
the analysis.
it. I don't mean to bowl you a fast.
No, not at all. I'm a big cricket fan, although batting's not great. But I would say that what is particularly key that comes out of that, I'll repeat it, if you go with the paragraph 12 St Barb Green reading of section 49, but then don't take with it the path that the first tier tribunal takes, i.e. to say that that deeming remains alive, retains vitality when one comes to look at what in effect is another section in the same Act, because we're told you have to construe the 86 Act with the 84 Act. Then you never get to ask the question, is this particular liability in this particular case deductible or not? Section 5.3 tells us that some will be deductible and some won't be. But if you go for an interpretation which basically says it's 49.1 plus 5.1 that does all the work, and if one shuts the door on first tier tribunal's analysis, which is the deeming really does mean what it says on the tin and is to be carried through when you look at other sections of the Act, then how do you ever get to ask the basic question, is this particular liability deductible or not deductible?
This is all slightly at a different tangent, isn't it? Because Mr. Justice Mann doesn't say, and sections 49 and 5 and all the others don't say whose liabilities these are that are deducted. He doesn't say, and they are deemed then to be under section 49 the liabilities of the life tenant.
Correct.
He just says you can't have more than you've got. And what you've got is something minus something because somebody has incurred a liability. It doesn't say whose liability.
Correct. He does not say
No.
that. We're going to come on to look at it. The first tier's view was that he doesn't say it, but it must be what he meant. The Upper Tribunal said he doesn't say it, and that isn't what he meant. But you're right, he does not say it.
No.
So, the basic point I've been making is that insofar as the Upper Tribunal founds its position on what is said in paragraph 12 of St Barb Green, we say that is not the surest foundation because, in my submission, what is said in paragraph 12 of St Barb Green is not correct. The primary contention is at paragraphs 12 and 13 of my skeleton. Now, if the court's not with me on that, then I say that the Upper Tribunal nevertheless misconstrued section 49.1 and misunderstood and or misapplied what Mr. Justice Mann was doing in St Barb Green. So this is my secondary contention on St Barb Green. It's paragraphs 14 and following of my skeleton. So I think the court has already got the point, but what I say in essence is that the Upper Tribunal should have held that any deeming effect of section 49.1 remained in play, as it were, when one comes to look at section 103. As I've already mentioned, just so we're all in the same place, the UT's essential reasoning, I say, comprised 2 points. First, that section 49.1 does not expressly refer to liabilities and could have, but does not require those liabilities to be treated as incurred by the life tenant. Upper Tribunal 58.3. And secondly, that in order to bring settled property into the life tenant's estate, it's not necessary for section 49.1 to treat the life tenant as the bearer of the liabilities. Upper Tribunal 58.7. Now, in relation to the first of those points, it's ground we've already covered, really, i.e., I do say it seems questionable to place undue weight on the fact that section 49 does not expressly refer to trust liabilities as being treated as those of the beneficiary, since section 49 doesn't, of course, refer to liabilities at all, full stop.
But it doesn't operate in a way that treats the beneficiary as if they're the trustee. That's the problem I have with it. It treats them as somebody who has a beneficial interest, which means they're not the trustee.
I'm not, as it were, ignoring your ladyship's point. I'm letting it breathe.
Mm.
And it may be that what I say as I go will be of assistance.
Mm.
But essentially, I say, so Upper Tribunal, basically 2 points. Number one, there's no express reference to liabilities in 49.1. Number two, it's not necessary for 49.1 to be read as treating the interest in possession beneficiary as bearing the liabilities. I've said a little about the first of those. As to the second, yes, Upper Tribunal 58.7, which we've already looked at, the Upper Tribunal says, Section 49.1 makes sense and fulfills its statutory purpose in that it operates to bring the settled property into the estate of the holder of the interest in possession. And then it goes on that in doing so, it does not require that settlement liabilities are to be treated as being liabilities of anyone, well, of the interest in possession beneficiary. Now, I say that's wrong, and I say that on the following basis. First, it is clear from the wording of Section 49.1 that its purpose is to at least treat the life tenant as the owner of the settled property. That's in effect what it says. And I would suggest, therefore, that if and to the extent that Section 49 is dealing with trust liabilities at all, it must be doing so on the same basis.
Well, what you're looking for is a double deeming, isn't it? Mm. Well, that's the way I see it. You deem the person who has the interest, the trust interest, to be the owner, and then you deem them also to incur the trust liabilities in that capacity. That's how you read 49.1.
I've got no difficulty with that label if that's
No,
preferred label, but I would see it all as part of the same deeming. But an extension of the same.
Okay, you would say it's inherent in the deeming that one is the owner, that one is also therefore taking on one's own shoulders the liabilities, despite the fact they have been incurred by the trust, but it's all part of the one deeming.
Well, that's the difficulty
Yes.
I have with it, because of the point I've just made, which is that you are being deemed to be the owner, but you're being deemed to be the equitable owner of the property by virtue of being treated as having a beneficial interest in it. And that's not the same as being treated as the legal owner, which would be the trustee. And it's because of the language of the section itself that I have that difficulty, because it talks about beneficial interest, doesn't it?
Should be treated for the purposes of this act as beneficially entitled.
Beneficially entitled. It could have said could be treated for all purposes as the outright owner or put in the same position as trustee, but it doesn't say that. It says beneficial entitlement.
It's beneficial entitlement in respect of the gross assets, as it were, on St Barb Green, but subject to this net property concept.
Can I throw another thought into the mixture here? I mean, this concept about beneficial entitlement and liabilities, in a general sense, supposing you buy a property with the benefit of a mortgage as your home to live in, I mean, nobody would say that the and from one point of view, your beneficial entitlement is only to the equity of redemption in the property in sort of monetary terms, but nobody would, for a moment, I think, question that you're correctly regarded as the beneficial owner of the entire property, in the sense that you have the legal estate vested in you and you can do with it what you will, and the fact you've bought the property with borrowed money may well give rise to an encumbrance, but it doesn't stop your beneficial ownership extending to the totality. And that is a common sense point of view. It seems to me a way of looking at these issues which really separates the concept of beneficial ownership on the one hand from deductible liabilities on the other. Of course, everyone realizes when you eventually have to translate your entitlement into money terms, you've got to provide for the liabilities in one way or another. And from that point of view, one sees where the idea of net property comes from. But on the other hand, that seems to me a wholly unrealistic way of looking at the situation on the ground.
And it also means, I'm going to keep banging this drum, because I think it really matters. If the question of the liabilities is simply dealt with by this concept of net property, when do you ever get to ask the basic question, is this liability deductible or not deductible?
Well, perhaps I'm just being... There's a danger of getting overcomplicated here. I think everybody must accept that liabilities which are an encumbrance on property ought to be deducted in one way or another, because otherwise you end up paying tax on a sort of gross amount which bears no relation to the value of what you actually have. So we find clues in the provisions in the 84 Act dealing with value, which seem to take it for granted, as you would expect, that liabilities which are encumbrances fall to be deducted. And that's then, that way of looking at it gets further support from the Investec case, which you haven't taken us to yet, perhaps you will be, where it's accepted that trustees who incur liabilities have a lien on the trust property pro tanto. Again, so far so sensible, I might think.
Except, my lord, that is a logically subsequent step in the process, because there is the initial question of whether the liability is, as it were, a good liability, whether it's one that does or doesn't fall be dealt with in a particular fashion within the inheritance tax regime. That's what Section 5.3 says.
Yes. Why is... perhaps I'm just...
Why does that matter?
Why does all this matter? And I think what Mr. Justice Mann said in that net property sentence, and I read that almost as a kind of throwaway remark, because he's treating it as pretty much common ground. That's what the revenues say, that's how they give effect to the section. And it's really just making the point I've been making, which is, well, ultimately, it would be an affront to common sense to say that you don't get a deduction one way or another for a liability which is an encumbrance on the property in which you have the beneficial interest.
Well, you may or may not get a deduction. It depends upon, as I say, whether it's the sort of liability which is caught by Section 103.
Well, it seems to me it is caught by Section 103 if, as a matter of real fact, it is a liability incurred by the trustees acting as such in relation to trust property vested in them. That gives rise to an Investec right of deduction, and that is the correct way to value the beneficial interest we're talking about.
Well, let me try to... I hear the point. Let me try to develop the argument, if I may. We're in the logical world of Section 49. That's what's referred to at paragraph 11 of St Barb Green. In which the trust assets are deemed by Section 49.1 to be owned by the person who's the relevant beneficiary. And I do say the FTT got it absolutely right in answering the question, which then falls to be asked, namely, in this logical world, who is to be treated as having incurred the trust liabilities? Now, the FTT dealt with that at 228. We'll come to that in a moment. But I do stress that the FTT did not consider they were doing anything out of kilter with what Mr. Justice Mann was saying in St Barb Green. It's perhaps worth briefly looking at the case of Fowler before we go to FTT 228.
Sorry, before you do that, on any view, Mr. Justice Mann, and he ends up justifying his decision on two alternative grounds, one of which is the, if you like, his net property concept, and the other one of which is the Section 5.3 approach, which I think is what revenue have always argued for, and still do, as I understand it. Not
Correct.
You're not saying anything wrong about that.
No.
So basically, Mr. Justice Mann is if you read his judgment as a whole, he's saying, well, that must be the right answer, and there are two alternative routes, either of which I'm happy to endorse to reach that conclusion.
Indeed. My submission is simply that we say that 13 is better than 12, but we can get home via either route.
Yeah.
Because the FTT considered that what it was doing was consistent with Mr. Justice Mann.
I mean, speaking for myself at the moment, I find the 13 route more attractive. The idea of a net amount seems unrealistic, going back to the point I was making about how anyone who owns a property subject to an encumbrance would think about it. You say you're beneficial owner of the entirety, but subject to an encumbrance which, in due course and in certain circumstances, will have to be taken into account by way of allowance or deduction.
Yes, and that is my primary submission as well, my lord.
I'm still utterly at a loss as to how this really helps on the basic proposition, which is that somehow the deeming of Section 49.1 is broad enough to turn the beneficiary into the person who's incurred the liability.
Well, could we go to Fowler, please?
Yes.
Oh, excuse me, go on.
Tab 41.
Thank you.
Malone Jr. is asking me to point out, quite rightly, that if you are going by the Section 5.3 route, then it's referring to his liabilities, i.e. you're treating the liabilities as his liabilities. And that is then consistent when you head over to Section 103 and look at the liabilities there. It's the point we make in paragraph 13 of our skeleton argument. So, Fowler, tab 41, page 737. I suspect this case will be familiar to the court. The facts are very different from ours. It's a saturation diver in the North Sea, and the question of whether the income is employment income or self-employment income. But it brought into focus a question of the effect and interaction of a double taxation agreement with a UK domestic piece of legislation. And the relevant paragraph is paragraph 27. And I appreciate that it'll be familiar, but I'd be grateful if the court would just remind itself of what is said there by Lord Briggs. I'm grateful for that. So that is the guidance that's given by the Supreme Court. And with that in mind, I would be grateful if we could go to the first tier tribunal's decision, paragraph 228.
Yes.
Where the tribunal starts in the first sentence by saying that they do consider that there is a necessary implication in the language of section 49 that the debts of the settlement should be treated as having been incurred by the person owning the interest in possession. And then they say they do so for the following reasons. The starting point in the analysis is the judgment of Man J and St Barb Green. It's clear from the judgment that Mr Justice Mann saw section 49 as bringing within the estate of the deceased the whole of the settled property, in which the deceased had an interest in possession, but as requiring the settlement liabilities to be deducted in valuing that settled property. In other words, Mr Justice Mann was not saying that the effect of the section was that the deceased did not have an interest in possession in the portion of the gross settlement assets which did not exceed the liabilities of the settlement. Were that to be the case, then the answer in relation to other issues would be very different. Instead, Mr Justice Mann was saying the effect of the section was to confer on the holder of an interest in possession deemed beneficial ownership of the gross settlement assets, but to take into account in valuing those assets the liabilities of the settlement. Since that is the effect of section 49, who else, apart from the holder of the interest in possession, which is to say the deemed beneficial owner of the gross settled assets, should be treated as having incurred the liabilities which are to be taken into account in reducing the value of the gross settled assets? Those assets are deemed to be beneficially owned by the holder of the interest in possession, but of reduced value to that holder by reference to the liabilities in question. We think that a necessary implication arising from that process is that the liabilities have been incurred by the holder of the interest in possession. My submission, in short, is that they got it right. It's worth noting that in saying they got it wrong, which the Upper Tribunal did, the Upper Tribunal did consider that a number of the principles in Fowler supported what the FTT said. So the court doesn't necessarily need to go there, but at Upper Tribunal 58, 4-6, the court considered that it would not be absurd to treat the debts as having been incurred by Mrs Elborne. That's Fowler Principle 4. And the court also considered the principle that a court should not shrink from applying the fiction created by deeming would, as the UT noted, quotes, support the state of affairs which is deemed to exist by reason of section 49(1) being applied when interpreting and applying other provisions, including section 103.
But I don't understand how this can be an inevitable consequence. It's something a Parliament might have provided by way of an additional express provision, but hasn't done so. And in the real world, the liability was not incurred by the life tenant, deemed or otherwise. It was incurred by the trustees. That's the point my lady was putting to you a long time ago. And at the moment, I'm finding it very difficult to see an answer to that point. And to say it's because in order to get within Fowler, you really have to say it's an inevitable consequence of the deeming that the life tenant herself is to be treated as the person who entered into the note. And that's just topsy-turvy. It's not what happened. It's all the wrong way around.
Apologies. Just to finish off.
Yes.
So the second point I was making, so the Upper Tribunal give a tick to Fowler Principle 4. Yep. They then give a tick to Fowler Principle 5.
Yep.
But they nevertheless reach a different view. And in doing so, I do say that the practical effect is stark. Because if you don't get the deeming running through from 49 to 103, the debt arising under the loan note falls to be deducted in a manner that, I say, circumvents section 5.3 with its link on to section 103. You don't get to ask the question whether this particular liability is the sort of thing that should be factored in under the inheritance tax regime. That's why the FTT said that the alternative analysis would drive a coach and horses through section 103 and its manifest purpose. So we do say that the Upper Tribunal was wrong to interpret St Barbe Green in a fashion which meant section 103 did not come into play. The FTT found a way to interpret St Barbe Green in a way which did allow section 49 to retain its vitality when one got to section 103. We've been talking about debt incurred. I've made a point about inconsistency. We've discussed St Barbe Green. I now want to say something about property derived from, which is our ground 3. Still dealing with section 103. So this is paragraph 21 and following in our skeleton argument. The court will recall that a little earlier I ran through the requirements of section 103 in headline terms and suggested, in line with the Upper Tribunal's categorisation, that one might see there as being 4 elements in play. There was no dispute over the first and the fourth. That left the second and the third. We've spent a bit of time looking at the second. We're now going to look at the third. This is the property derived from point. So, having established that there's a liability which on the face of things falls within the section, or if one has, the statute then refers to the liability being subject to abatement to an extent proportionate to the value of any consideration given for the debt which consisted of property derived from the deceased. So this element of the legislation has to be fulfilled if the section is going to apply. The revenue submission is that it is fulfilled, and that was also the finding of the FTT. So, for the court's note, we will come to it, but that's FTT 235 plus FTT 212. The Upper Tribunal's conclusion was to the contrary. Upper Tribunal 60 to 69, with a conclusion at 69. And our appeal against the Upper Tribunal's conclusion here is our ground 3. So, taking the analysis in stages, I say it's important to keep in mind what we're looking at here. The transactional structure in this regard is very simple. The debt, to use the word in section 103, we're looking at is the liability under the loan note. It's the obligation on the part of the life trustees to pay the sum due under the loan note. And the consideration, to use the word in section 103, for the debt is the transfer of the freehold of the property under the agreement for sale. That's it, i.e. Mrs Elborne transfers over the freehold and in return she gets the loan note. Clause 5 of the agreement for sale essentially states as much. It says the purchase price shall be fully satisfied by the buyer issuing to the seller a promissory note in the form attached to the sale agreement.
It's the consideration for the sale.
So there's no question what the debt is, and there's no question what the property is. That's the freehold. And the statute asks very simply whether any of the consideration given for the debt consisted of property derived from the deceased. And I say the answer is yes. Indeed,
The loan note is not property derived from the deceased, it's a loan note.
I'm sorry, my lady.
The loan note is the consideration. The loan note is not property derived from the deceased. It's a pronote.
No, the freehold is the consideration.
No, it's not.
No.
The debt is what is due in return for the transfer of the freehold. Selling the freehold, and a debt is incurred, which is the money that is due under the promissory note for that property.
Yes, it obviously depends which side of the
The
transaction.
property's not a debt.
No, it isn't.
Right. So the only debt that one can have is the liability that is incurred under the promissory note. And the promissory note is not property derived from the deceased. It's a promissory note.
That's right. I think we're in violent agreement.
Yes.
Good.
Right.
So tell us.
So tell us how it fits then, because at the moment I'm not quite sure where you get the property derived from the deceased being the freehold.
Just so that, to repeat yet again the matter, so we've got the property going from the deceased to the life trustees, and in consideration for the property, the life trustees, who happen to be her and her solicitor, give a promissory note for, if you like, the price of the property. So they incur a liability wearing their trustee hat.
So the footing on which we're looking at Section 103
Yeah.
is the footing on which, because of the deeming in Section 49, and because of what Section 5.3 says, or because of Section 5.3, the debt incurred is the debt incurred by Mrs Elborne. We say, with the first tier tribunal...
What is that debt? Just spell it out for me. What do you say she owes?
So we're within the logical world of Section 49, which has deemed Mrs Elborne to be the owner of the trust assets. And we say, logically, that means she also bears the liabilities.
She's not a party to the Crown Note other than in the position as a trustee.
So within the logical world of Section 49,
You say she bears the liabilities,
yes.
but that doesn't mean she's liable for them.
It means that when you ask the question under Section 103, who has incurred the liability, the answer is, it's the same person who is deemed to own the trust assets, i.e. Mrs Elborne.
That reads an awful lot into the section.
No, but that's your double deeming, or my double deeming, and your wide deeming of Section 49, so that she's deemed to own the property and bear the liabilities. But I need another link to get where you are, so tell me again.
So we're within Section 103.
Yep.
On the FTT's analysis, when you come to look at Section 103, you have to ask who has incurred the debt in question. The answer is, by virtue of the deeming of Section 49.1, it's Mrs Elborne.
Okay.
And so the debt is the liability under the loan note.
Yes.
She's treated as owing money to herself.
Well, if I just work through...
Is that the way that it works? I mean, so she's treated as both the buyer and the seller of the property, and she's treated as actually owing a debt to herself in relation to the property that she sold to herself. In the world of Section 49. That must be right, mustn't it?
I mean, the short answer is
Yes.
yes.
I mean, you may be right, but it does seem rather bizarre.
The shorter answer is it's correct, and that's also the view that the FTT took, and it's also the Upper Tribunal's position that that is not an absurd outcome.
But can you take me to the end? Because we're not quite down the chain.
Yep.
So we're in the Section 49 world.
Yep.
So it's a debt incurred by Mrs Elborne.
Yes.
She's transferred the property. She's got the loan note, but because we're in 49, it's a debt incurred by her.
Yes.
But then from property derived from her. So that's background, because none of this would have happened unless she owned the property in the first place.
Yes, so the property derived from her is the freehold. So let me, perhaps if I work it through again.
Mm-hmm.
So the debt we're looking at is the liability under the loan note. And in the Section 49 logical world, that is a debt, we say, and the FTT says, to be treated as incurred by Mrs Elborne. What's the consideration for that debt? It's the transfer of the freehold of the property. Therefore, the question is that consideration property derived from the deceased? And the answer is plainly yes. It's the property. It's property from the deceased, of the deceased, derived from the deceased, drawn from the deceased. One might say it in any of a number of ways. Emanating from the deceased, originating from the deceased. It's the freehold. It's the very thing that she is transferring. So, what I'm saying here is that the meaning of the words property derived from the deceased here, it's a reference to the freehold, and you get a tick because it is plainly property derived from Mrs Elborne. It's worth noting that this is the same conclusion that has been reached on exactly the same point in another case, and I'd like to go to that very briefly, if I may. The case is called Pride, and it's in the authorities bundle at tab 50. Page 1108.
This is FTT decision.
It's an FTT decision. It's another iteration of the home loan scheme. The FTT determined it against the taxpayer, i.e. they found that the scheme did not work. The facts of the scheme were slightly different from the present in that there were two property transactions rather than one, but the fundamental point, i.e. how to analyse a loan note at the heart of the structure, was the same. And in the course of argument, this point about property derived from came up. And could we go to page 1118, please? The authorities bundle. And I'd be grateful. Well, hopefully at the top of the page there is a heading, did the consideration given for the loan notes derive from Mrs. Fry? And then at paragraph 52, the tribunal is, as it were, setting out the basic mechanics of section 103. We see the second sentence of 52. Then at 53, there's a reference to meaning of property. There's also a reference there to section 114 of the Finance Act, 1145, which talks about the 84 Act and the 86 Act being construed as one. And then could I please ask the court to read 54 to 56, in particular 55. I'm grateful. So we say that is the correct analysis and conclusion. And it's also where the FTT got to in our case at FTT 235, second sentence, and 212, second and third sentences. So why did the Upper Tribunal reach a different conclusion? Well, in essence, the Upper Tribunal took the view that it's a necessary condition of Section 103 applying in relation to a debt that there are two transactions, not one transaction. The nub of the Upper Tribunal's decision on this is Upper Tribunal 63, paragraph 63, which says this: on the basis of the structure and language of Section 103, we agree with Mr. Bradley that Section 103 envisages and requires two transactions, that which involved the creation of the liability consisting of a debt incurred by the deceased, and one which any property was the subject matter of a disposition made by the deceased. The separation between the two transactions, which was identified by the FTT in the context of the Section 103 encumbrance issue, applies to liabilities consisting of debts incurred by the deceased, as well as to encumbrances created by a disposition. This means that the property which was transferred to Mrs Elborne to the life settlement in consideration for the issue of the note by the life trustees cannot also be property derived from the deceased as defined in 103.3 for the purposes of 103.1a. So that's why the Upper Tribunal said this was not property derived from the deceased. Various points to make about that. First, nowhere in Section 103 is it stated, i.e. expressly, that there must be two transactions rather than one in relation to a liability consisting of a debt. It would have been perfectly easy for Parliament to have stated that in terms. It didn't. Secondly, if the Upper Tribunal's and my learned friend's preferred construction is correct, then Section 103, which I say is an important anti-avoidance provision, is astonishingly easy to circumvent. That's not an outcome which this court should rush towards unless absolutely driven there by the statutory wording. Thirdly, the Upper Tribunal refers to the FTT's decision, and it's worth seeing what the FTT said. Could we go to the FTT's decision, please? First of all, to paragraph 235. And this says there are two final points which should be made in relation to the Section 103 debt incurred issue. The first is that we should say that in our view, although there's no need for there to be two dispositions of property in a case where Section 103 is being invoked by reference to the existence of a debt incurred, as opposed to being invoked by reference to a creation of encumbrance, so there isn't the same difficulty in squaring the language used in Section 103.3 with the language used in Section 103.1, to which we've referred in paragraphs 214 to 215 above. The same timing point in relation to Section 103.3, to which we referred in 212 above, arises in this case. This is because the beneficial ownership of the property, which amounted to consideration for the issue of the note, passed to the trustees of the life settlement simultaneously with and not before the issue of the note. For the reasons set out in 212, we consider that that's not fatal to the respondent's case in relation to this issue. We would add that in any event, on the present facts, it would be very peculiar if the application of the section were to turn on the fact that the consideration given for the issue of the note was provided simultaneously with and not a scintilla of time before the issue of the note. So, there's quite a lot going on there, but various points to distill from it, if I may. First, the FTT says there's no need for there to be two dispositions rather than one in the case of a debt. We say that's correct. Secondly, the FTT contrasts that with the position in respect of an encumbrance case. Now, as the court is aware, Revenue argued before the FTT that the case could be analysed through the encumbrance lens, as it were. The FTT found against us, and we didn't appeal that. But in any event, just so the court has it, the FTT notes that the statutory language differs depending on whether you're looking at debts or encumbrances. So one refers to a liability consisting of a debt, and the other refers to an encumbrance created by a disposition made by him. So the FTT noted, this is at 214, 215 and 235, that there's a difference in language. Before this court, our focus is purely on the debt language. Third point to make in relation to 235, the FTT refers to a timing point. It says, although there's no need for there to be two dispositions of property in a case where Section 103 is being invoked by reference to the existence of a debt incurred, the same timing point in relation to Section 103.3, to which we referred at 2112 above, arises. So what's the timing point? The timing point is that of whether the word was in inverted commas, bears the weight that the other side say that it bears. Section 103.3 offers a definition of property derived from the deceased for the purpose of Section 103.1. It states that property derived from means any property which was the subject matter of a disposition made by the deceased. Now, the FTT rejected the submission advanced by the other side. This meant there had to be two transactions rather than one. Could we go to FTT 212, please? Third sentence. Well, second sentence, he, that's learned friend, has not convinced us that the use of the word was in 1033 means that disposition of property, which is represented by the consideration for the creation of encumbrance, need necessarily to precede the disposition, which creates the encumbrance. We agree with Mr. Davey that the use of the past tense is adequately explained by the fact that Section 103 is necessarily looking back in time from the point immediately before the deceased's death. I say that's a correct finding. There was obviously the tribunal's point about it would be a bit odd if a scintilla of time made all the difference. I've made 3 points about paragraph FTT 235, and a fourth point on it. We do make the point that Section 1033 gives a wide definition of property derived from the deceased, as one might expect in an anti-avoidance provision, and that the Upper Tribunal's preferred construction, read in conjunction with 103.1, i.e. saying that there have to be two dispositions, would have the result of narrowing what would fall within property derived from the deceased in my submission a fundamentally counterintuitive way. So as we put it in our skeleton at paragraph 23, as a matter of ordinary language and on a real-world analysis, the property really was property derived from Mrs Elborne. It's the house which she lived in respect of which she was the freehold owner, the disposition of which constituted the consideration for the debt. That's how we put the point. Now, my learned friend says that analysis misses the mark. But I say that criticism itself misses the mark. There are 2 points here. If it's helpful, we can turn up the Elborne party skeleton, or I can just make the submission. But 2 points are made against me. This is Elborne Skeleton, paragraph 21.1 and 21.2. The first is this. It states this: the provision is broad in scope, but the breadth comes from Lim B, to which the structural requirements identified by the UT in relation to Lim A do not apply. As already mentioned, however, the revenue do not rely on Lim B before the UT. So Lim A was property derived from deceased, and Lim B was a different formulation. Consideration not being property derived from deceased, given by any person, etc. Well, I say no. That complaint itself misses the mark. It's true that the revenue is not seeking to rely on 131B, but what drives the construction, which I do contend for, is the simple meaning of the phrase property derived from deceased within the fact pattern that we've got here. The second point made against me is this. So this is Elborne Skeleton 21.2. It's not at all surprising that a section such as Section 103, which evidently envisages analysis of actual historical transactions between at least two persons, should be inapplicable to a notional transaction in which Mrs Elborne is deemed to be both borrower and lender. The exclusion of such notional transactions from the ambit of 103 does not materially diminish its effectiveness in the cases at which it's actually aimed. So the contention is that it's not at all surprising that Section 103 doesn't apply in a situation like this. But I say why? First, insofar as one's asking the question whether the freehold of the old rectory is to be regarded as property derived from Mrs Elborne, there's nothing notional going on at all. The consideration is the house. Secondly, I do say there's no legitimate basis for saying, in effect, as it were, in principle, Section 103 does not come into play in analysing arrangements such as in the present case. There's a question about the extent of the deeming in 49, but there's no in principle bar on reading it through to 103. My submission is that that would make sense commonsensically. I would also remind the court that we're told to read the relevant provisions of the 84 Act and the 86 Act as one, construed as one. So I do say, the learned friend is assuming the very point in issue, making the point that he does. At all events, I say that the property derived from requirement is met. So if I draw those various points together in relation to Section 103, I say that the Section 49 deeming does retain its vitality when one gets to Section 103. That's what the FTT found, we say correctly. The Upper Tribunal franked it in part in saying that some of the Fowler principles were met, but not all. My Lord Sir Launcelot Henderson says, I think the point is, it could be logical, but is it necessary? I think that's one of the points that the court is making. My submission is that it certainly is logical, and it's consistent with the language of Section 5.3, as I say, debt incurred by him. But also, the elephant in the room remains that if one doesn't bring it across to Section 103, then there is this lacuna where one never gets to ask the question whether or not this liability is deductible or not deductible. Fowler talks about deemings being sort of driven by language and logic, as it were. I say the logic is very strong here. When do you ever get to ask the question whether or not this liability is properly deductible if you don't go through the route to section 103? And then I do say once within section 103, the liability under the loan note is captured by the provision. Remember, there were 4 elements to section 103. Number 1, you need a situation where one is determining the value of a person's estate immediately before death. There's a tick there. You need a liability consisting of a debt incurred by him. Well, I say there's a tick there. That's a function of the inevitable consequence of the deeming in section 49. Element 3, one's looking for a situation where the consideration comprises property derived from the deceased. I say there's a tick there, the house. And then number 4, in those circumstances, the abatement of liability is to the extent proportionate to the value of that consideration. And here, it's not in dispute. That abatement would be 100%. So that's grounds 1 to 3. The next place I will go, if I may, may I just have one moment? The next place I will go, if I may, is ground 7, which is statutory construction. We're factoring in Rossendale. I want to deal with ground 7 now because, like grounds 1 to 3, it focuses on liabilities. We deal with it in our skeleton at paragraphs 37 to 40. It's dealt with in the FTT's decision at 183 to 198. It's dealt with in the Upper Tribunal's decision at 118 to 137. And I'd like to start by making sure that the context of the submission is understood. In advancing grounds 1 to 3, I have in essence been making the submission that the scheme fails by virtue of a combination of section 49 coupled with section 103. I've been submitting in line with the FTT's conclusions at 226 to 246, and contrary to the Upper Tribunal's conclusions, that the logical consequence of the section 49 deeming that an interest in possession beneficiary is treated as owning the trust property is that when it comes to looking at section 103, the same individual is treated as owning or incurring the trust liability. However, before the FTT and before the Upper Tribunal, there was a distinct vein of argument advanced by the Revenue in relation to section 49, which now finds expression as ground 7. Since it's based at least in part on the Supreme Court case of Rossendale, and we haven't looked at Rossendale yet, I'm going to take things in 2 stages. Number 1, take the court through the relevant passages of Rossendale, and then number 2, set out what that means for the present case. So the first of those 2 elements, could we go to Rossendale, please, which is in the authorities bundle. At tab 42. So, Rossendale was a ratings case, specifically dealing with a business rates tax avoidance scheme. But, I say relevant for what the Supreme Court enunciates as a matter of principle and approach. What was before the court is summarised neatly in the first 2 paragraphs of the decision. The question on these appeals is whether the appellant local authority have reasonable grounds for claiming non-domestic rates on certain empty properties from the respondent companies in bare outline non-domestic rates are charged on the occupier of a property which is not a domestic property, or if the property is unoccupied, on the owner of the property subject to certain exceptions. The owner is defined as the person entitled to possession of the property. One of the exceptions is where the owner, as defined as a company in liquidation, including voluntary liquidation. The respondents are the registered owners of various unoccupied commercial properties who sought to avoid liability for business rates by means of one or other of two closely related schemes. Both schemes involve setting up a special purpose vehicle in the form of a company without any assets or business. Registered company grants a short lease of the unoccupied property to the SPV. The premise of the schemes is that the SPV thereupon becomes the owner of the property. The SPV is immediately put into members' voluntary liquidation or alternatively is dissolved. In the liquidation version, reliance is then placed for as long as possible on the exemption which applies where the owner of the property is being wound up. The dissolution version of the scheme relies on the fact that upon dissolution, the lease and associated liability for rates is automatically transferred by law as bona vacantia to the Crown. Meanwhile, the registered owner is relieved from paying business rates either until it terminates the lease before it has a tenant or other use for the property, or until the lease is disclaimed by the liquidator or by the Crown. On the assumption that the scheme works at all, both versions rely for their effectiveness over time upon administrative inertia. So that's what it's about. And then if we skip down at paragraph 5, it's noted that it's common ground that the schemes have no business or other real-world purpose and that their sole purpose is to avoid liability to pay business rates. Then over the page at paragraph 9, we have a heading, the Ramsey principle. So paragraph 9 is introductory, including 3/4 of the way through. Although usually deployed in relation to tax avoidance schemes, it's not in its essential particulars to tax. Being based upon the modern purposive approach to the interpretation of all legislation. At 10, there are supporting quotes. And then at 11, the court says this: the result of applying the purposive approach to fiscal legislation has often been to disregard transactions or elements of transactions which have no business purpose and have as their sole aim the avoidance of tax. This is not because of any principle that a transaction otherwise effective to achieve a tax advantage should be treated as ineffective to do so if it is undertaken for the purpose of tax avoidance. It is because it's not generally to be expected that Parliament intends to exempt from tax a transaction which has no purpose other than tax avoidance, as Judge Learned Hand said in Gilbert and the Commissioner for the Inland Revenue, in a celebrated passage cited in part by Lord Wilberforce and Ramsey. If the taxpayer enters into a transaction that does not appreciably affect his beneficial interest except to reduce his tax, the law will disregard it, for we cannot suppose that it was part of the purpose of the Act to provide an escape from the liabilities that it sought to impose. And then, first sentence of 12, another aspect of the Ramsey approach is that where a scheme aimed at avoiding tax involves a series of steps planned in advance, it's both permissible and necessary, not just to consider the particular steps individually, but to consider the scheme as a whole. And then over the page again, at 16, both interpretation and application share the need to avoid tunnel vision. The particular charging or exempting provision must be construed in the context of the whole statutory scheme within which it's contained. And at 17, the facts must also be looked at in the round. In Magoukian, Lord Steyn explained that it was the formalistic insistence on examining steps in a composite scheme separately that allowed tax avoidance schemes to flourish. And then, over the page again, the court turns to the legislation, the rating legislation at paragraph 18 and following. And on the face of the things, the nub of the point which the court was looking at might have been thought to be ostensibly simple enough, i.e. whether or not parties constituted owner under section 45. And the reason that it might have been thought to be relatively simple was that the term owner was defined under section 65, using what certainly in the law of real property context would appear to be fairly basic, well-recognised words and concepts. Quotes, the owner of a hereditament or land is the person entitled to it. I think entitled to possession of it, entitled to possession of it. That had led the judge at first instance and the Court of Appeal to decide the case in the way that it did, in line with what might be called an orthodox or perhaps normal reading of that definition. However, the Supreme Court reached a different view. If we turn to paragraph 47, please. If we see the first sentence there, applying the legislation to the alleged facts, there can be no doubt that the definition of the owner of a hereditament in section 65(1 as the person entitled to possession of it is to be interpreted as denoting, in a normal case, the person who, as a matter of the law of real property, has the immediate legal right to actual physical possession of the relevant property. Then moving on to 48, first sentence. In the unusual circumstances of this case, however, identifying the person entitled to possession in section 65(1 as the person with the immediate legal right to possession of the property would defeat the purpose of the legislation. And 49, in our view, Parliament cannot sensibly be taken to have intended that the person entitled to possession of an unoccupied property on whom the liability for rates is imposed should encompass a company which has no real or practical ability to exercise its legal right to possession and on which the legal right has been conferred for no purpose other than the avoidance of liability for rates. Still less can Parliament rationally be taken to have intended that an entitlement created with the aim of acting unlawfully and abusing procedures provided by company insolvency law should fall within the statutory description. In these circumstances, we've no difficulty in concluding that on the agreed and assumed facts, the SPVs to which leases were granted as part of either of the schemes we described did not thereby become entitled to possession of the demised premises for the purpose of the Act. Rather, throughout the term of the lease, the person remained the defendant landlord. This does not involve ignoring the leases in the way that an intermediate element in a circular transaction might be ignored under the Ramsey Doctrine. Rather, it involves their close examination in their context and a conclusion that they did not transfer to the SPVs the entitlement to possession required by the Act as the badge of ownership. And then finally, 51 and 61. At 51, we emphasise that this conclusion is not founded on the fact that the defendant's only motive in granting the lease was to avoid paying business rates, although that undoubtedly was so. The leases entered into by the defendants had the effect that they were not liable for business rates. Their motive for granting the lease is irrelevant, nor does it illuminate the legal issues to use words such as artificial or contrived to describe the leases. When it's now accepted they created genuine legal rights and obligations, were not shams. Our conclusion is based squarely and solely on a purpose of interpretation of the relevant statutory provisions and an analysis of the facts in the light of the provisions so construed. Final paragraph, 61. First sentence, it may be that other factual situations may demonstrate that this test needs some refinement. That's having set out what they say the test is. And then picking it up a sentence later, 3 up from the bottom. We would, however, reject that criticism that the test is insufficiently certain. In an ordinary case, the test will easily be satisfied by identifying the person who's entitled to possession as a matter of law of real property. The fact that the law of real property may not prove a reliable guide in an unusual case, the present kind, is not, in our view, an objection to our preferred interpretation. The value of legal certainty does not extend to construing legislation in a way which will guarantee the effectiveness of transactions undertaken solely to avoid the liability which the legislation seeks to impose. That is Rossendale. By my watch, it's 12:59.
Yes, I was going to say, and is that a convenient moment?
That's a very convenient moment.
And how are you doing?
In terms of time, I'm doing very well. It's all fine.
Thank you. 2 o'clock then.
Thank you.
Court rise at evil.